5 seconds to go. Start. It would mean the court which had passed the decree or where the application under section 28 of the Act of 1963 is filed. In the case of Sardar Mohar Singh Supra, this court had held that the court does not lose its jurisdiction after the grant of decree for specific performance, nor it becomes functus officio. This court had further held that the very fact that Section 28 of the Act itself gives power to grant order of rescission of the decree, the same would indicate that till the sale deed is executed in execution of the decree, the trial court retains its power and jurisdiction to deal with the decree of specific performance. The court has the discretion to extend time for compliance of the conditional decree as mentioned in the decree for specific performance. One very unusual contention was raised by the learned counsel appearing for the appellant as regards the failure on the part of the decree holder plaintiff to deposit the balance sale consideration within 20 days from the date of the judgment passed by the High Court in second appeal. The argument is that the trial court, while allowing the suit filed by the plaintiff for specific performance, had specifically directed that the plaintiff shall deposit the balance sale consideration with the court within 20 days from the date of the judgment passed by the trial court. According to the learned counsel, this very decree passed by the trial court came be affirmed by the High Court in second appeal, and therefore the plaintiff was obliged to deposit the balance sale consideration within 20 days from the date the High Court delivered its judgment in second appeal. This argument proceeds applying the doctrine of merger. We do not find any merit in the aforesaid submission canvassed on behalf of the appellant herein. In the aforesaid context, we may refer to the observations made by the Chief Justice M.C. Chagla, as his lordship then was, in the case of Commissioner of Income Tax Bombay versus Teja G. Farsaram, reported in AIR 1954, Bombay 93. We quote the relevant observations as under. It is a well-established principle of law that when an appeal is provided from a decision of a tribunal and the appeal court, after hearing the appeal, passes an order, the order of the original court ceases to exist and is merged in the order of the appeal court, and although the appeal court may merely confirm the order of the trial court, the order that stands and is operative is not the order of the trial court but the order of the appeal court. The doctrine of merger or the merger doctrine in civil proceedings is a common law doctrine that stems from the idea of maintenance of the decorum of the hierarchy of courts and tribunals. The court in the case of Gozer Bros Private Limited versus Ratan Lal Singh, reported in 1974 to SCC 453, correctly summed up the meaning of the doctrine as the doctrine is based on the simple reasoning that there cannot be at the same time more than one operative order governing the same subject matter. To put it simply, if there are two orders passed on the same subject matter, that is, one passed by a subordinate court like a tribunal and another passed by a superior court like the High Court, the operative part of the order by the subordinate court, tribunal in this instance, may be merged with the order of the High Court. In the case of Commissioner of Income Tax Bombay versus Amrit Lal, Bhogi Lal and Company reported in 1958-34 ITR 130. This court in para 10 observed as under. There can be no doubt that if an appeal is provided against an order passed by a tribunal, the decision of the appellate authority is the operative decision in law. If the appellate authority modifies or reverses the decision of the tribunal, it is obvious that it is the appellate decision that is effective and can be enforced. In law, the position would be just the same, even if the appellate decision merely confirms the decision of the tribunal. As a result of the confirmation or affirmance of the decision of the tribunal by the appellate authority, the original decision merges in the appellate decision, and it is the appellate decision alone that subsists and is operative and capable of enforcement. Thus, the Supreme Court merely reiterated the observation of Bombay High Court in the case of Tejaji Farsaram Supra and stated that the hierarchy of courts and tribunals is to be maintained when the decision is reversed by the superior court and even when the superior court merely affirms the decision of the subordinate court. Thus, the High Court, while allowing the second appeal filed by the original plaintiff, had not issued any specific direction as regards the deposit of the balance sale consideration within a particular period of time. It is incorrect on the part of the appellant herein to say that since the trial court had directed that the balance sale consideration shall be deposited within 20 days, the same direction would be applicable even after the judgment of the High Court in second appeal. Before we close this matter, we must deal with the judgment of this court in the case of Prem Jeevan versus K.S. Venkata Raman and another, reported in 2017-11 SCC 57, on which strong reliance has been placed by the learned counsel appearing for the appellants herein. In the said case, a decree for specific performance was granted in favor of the plaintiff as follows. In the result, the suit of the plaintiff is decreed with cause directing defendant 1 to execute and register sale deed in favor of the plaintiff in respect of the suit scheduled property within 2 months from the date of this order after receipt of balance sale consideration of rupees 10,50,000 with 6% per annum from 27 September 2002, that is from the date of agreement of sale. It is further decreed that in case defendant 1 refuses to receive the balance sale consideration with interest, the plaintiff is at liberty to deposit the said amount into the court and to obtain regular sale deed through court. The plaintiffs therein claimed to have issued a check on 4th December 2008 for the amount in question, but the same was returned as not accepted by the judgment debtor, who was the appellant before this court. Stop.